Welcome to HR Talk, where this week we're discussing the legal aspects of long-term sickness absence. I'm joined this week by Catherine Turner, who's an employment lawyer with Berwin Leighton Paisner. Hello, Catherine.
Hi, Jill.
There's been a lot of case law over the past few years on accruing and carrying over holiday not taken during sick leave. Can you explain where the courts have got to on this?
Well, there's been a number of cases where there's been some really good clear points that have come out from the courts, and most of the cases are from the Court of Justice of the European Union. So in terms of the main points that have come out, the first point is that workers can actually accrue holiday when they are on sick leave. And that point has come out of the well-known Stringer case, which is the Court of Justice case. The second point is that workers can actually choose whether or not to take holiday during a period of sick leave. And some workers actually like to do that because if they don't actually have contractual sick pay, it actually makes more sense for them to have a bit more money. And normally employers are absolutely fine with that. Now, the third point, which is an interesting point, is that workers who are actually prevented from taking holiday due to sickness, or if they're unwilling to take annual leave when they're off sick, they should be able to take it when they return to work. And that might mean that they have to carry holiday over. And that comes from the Court of Justice case of Pereira. The fourth point is actually a fairly recent point, and it's about not being able to carry over indefinitely. So there's been a recent Court of Justice case which points out that after a certain period of long-term sickness, it defeats the purpose of the directive because you're not actually giving employees a break from work. And in that case, the Court of Justice actually said it wasn't contrary to the directive for an employer to say that the worker had to take their holiday within 15 months after the end of the relevant year. So that's an interesting case, and we'll just see where we end up, if it's 15 months or maybe if that changes over time. And then the final point that I wanted to make, and it's a fairly recent case, but this time it's not the Court of Justice. This time it's an EAT decision, and it's the case of Fraser. And in that case, it came out as part of the judgment that an employee would need to ask their employer or request that they could actually carry holiday over. And so and if they don't do that, then the entitlement would be lost. So it'll be interesting to see where we end up with that and whether the Court of Appeal would agree with that. Because at the same time as we had this case, we had another case, and that said the opposite. So those are some of the key points that have come out of the Court of Justice case law and out of the EAT as well.
So how do these decisions sit alongside the UK's working time regulations?
Well, at the moment, they sit uncomfortably because fundamentally the working time regs actually say that where we're talking about the 4 weeks statutory annual leave, that you cannot carry that over. It creates some difficulties because you have the member states of the European Union who are obliged to implement EU law in accordance with the jurisprudence of the Court of Justice. At the same side, you've got tribunals and courts who will try and interpret UK law consistently with EU law. But where they can't do that, it actually gives tribunals and courts a bit of a get out, and they can actually stick to the letter of the UK legislation. So what we have actually seen is we have tribunals who have taken the decision to stick to the letter of the law under the working time regulations and actually said, no, you can't have carryover, which obviously very good for employers. And then at the other side, you have more recently, you've actually had tribunals that have turned around and actually written in some legislation themselves as part of their judgment. So that seems to be where we're going. We're having tribunals coming out with different decisions just because of the inconsistency between UK legislation and EU law. One of the things that's probably worth mentioning is the government consultation on modern workplaces, because there's a number of elements of what that consultation is about, but one of them is about proposed changes to the working time regulations, and that's to try and bring it more into line with EU law. And as part of that, it will make it clear that employees who are actually off sick and who haven't been able to take their holiday, that they will be able to carry that over. There'll be some restrictions around it, so the idea is that the employer can try and insist that the worker employee should be, if they can take it before the year end, then they should do, but if they can't, then it'd be able to be carried over. So I think we just need to wait and see what that's going to look like.
Given these case law and legislative complications, how should HR be handling holidays and long-term sick leave?
That's a difficult one, and I think there's no easy answer for employers just because of the inconsistencies. And what we've seen is you have the employers who actually opt for the safe route and they allow employees to carry over holiday. And you also see some employers who also accept that employees who have been on long-term sick actually accrue holiday while they're off sick as well. On the other side, you get employers who are willing maybe to take a little bit more of a risk, understanding that there is this inconsistency between UK and EU law. And what they might do is allow a certain amount of carryover, or maybe take some discretion in terms of who can actually carry over and how many days. And when it comes to long-term sickness, unless the employee pushes a point, either in terms of the holiday that they might want to take, or if their employment is terminated and they need to be paid for any accrued and untaken holiday, in the first instance, they might not give them for the previous kind of 2 or 3 years or how long they've been off sick. So it's just interesting to see the different approaches by employers. But the one point to note is that there is a risk. If the employer isn't following the EU legislation, there is a risk. And especially now we know that there are these proposals that may come into legislation which are just going to make it clear in terms of the working time regs about carrying over of holiday.
So what one thing would you want an HR department to do on this?
Well, what I tend to advise is that when we come to long-term sick employees, that we talk about active management and active management of that employee being off sick from a very early stage. Because what you tend to find is there are long-term sick employees where the employer hasn't been in touch with them for such a long time. So the idea is keep in touch with your employees, do it quickly so you can actively manage. And if it means that at one point the employee their employment is terminated, then in a sense you're avoiding the issue about them storing up maybe 2-3 years of accrued untaken holiday that they either have to take at some point when they come back or that you're going to have to pay out on termination.
That's all we've got time for this week. So Catherine, thanks very much for coming in.
Thank you.
And until next time, goodbye.